Good morning. Actually, the Prevention of Corruption Act cases were normally conducted by exclusive advocates who are acquainted with the procedures of department, and sometimes happens even the departmental officials recommend that particular advocates, because or some advocates who resign from departmental post, if commences practice, they are being selected. So that area of practice was exclusively controlled by one section of lawyers. But later on, due to latest amendment of Prevention of Corruption Act, which empowers to include third party persons also, because nowadays the persons indulging in corruption cases used to engage third party and private persons to collect bribe and allow them to be present inside their official premises as if he is one among the staff. Therefore, nowadays there is possibility of coming to cases outside this chamber of area of lawyers who conduct exclusively anti-corruption cases. Therefore, nowadays multi-number of advocates are also pouring in practicing Prevention of Corruption Act. So, a judgment which may help you how to conduct these Prevention of Corruption Act cases. Number one, the offer, acceptance, and the trap chemical test. Apart from all this, sanction is plays a pivotal role in conducting prosecution of Prevention of Corruption cases. AAR 2022 Supreme Court 4974. AAR 2022 Supreme Court 4974. Vijay Rajmohan versus State represented by Inspector of Police. They said for conducting Prevention of Corruption Act, the following acts are most important. Number one, Prevention of Corruption Act, Central Vigilance Commission Act, and DOTP rules, Department of Personal Authorities, DOPT authorities, then Criminal Procedure Code, and a special act empowering the rules regulating the proceedings of special judges. These all are things. Here, in these cases, there were two grounds were raised before the lower court. Number one, that there was influence of CVC while granting sanction. The sanctioning authority, after obtaining advice from CVC, seems to have granted sanction. So there may not be a proper application of mind. That was the one ground. Other ground was, they said there was a delay in according sanction. These two grounds were rejected by the lower court, and subsequently High Court of Madras allowed these petitions. Therefore, the case went to Supreme Court. I am sorry, one more thing. I will read it. The appellant challenged the order of High Court of Judicature allowing criminal revision petition filed by the state, discharging the appellant on the ground that the order of sanction is vitiated due to non-application of mind by sanctioning authority. The appellant is an official of Central Security Service. Therefore, the allegation was disproportionate to his income. Then the CBI filed the investigation. Then the appellant filed a discharge application under 227 of CRPC before the special judge. This application was filed on the ground that the sanction order was passed without this trial court by its order allowed the application. Allowed the application and discharged the appellant. Therefore, High Court went to Supreme Court and went to High Court, and High Court set aside the discharge application. That resulted going to Supreme Court. I am very sorry, I am very hasty in reading that. Now, it is clear that the application filed under 227 CRPC was allowed by the lower court. Therefore, the High Court intervened. The Supreme Court dismissed the appeal by holding that, number one, that the delay is vital. They say, yes, there was a delay, it is vital, but however, they say that itself is not sufficient to quash the proceedings. The second ground was the advisory proceedings from CVC, Chief Vigilance Committee, is a procedural one. Still, the DOPT authority has got independent mind to accord sanction. Therefore, that may not be ground to set. Therefore, the Honorable High Court order was upheld. They dismissed the appeal filed by the Vijay Narayanan. And it is up to the trial court to decide their judicial review of sanction. So this is what had happened. So kindly go through the judgment entirety, then I will come. The another aspect was for young lawyers. I would like to bring an important alert notice. For the past 1 week, the young lawyers who are recently enrolled are being misused, allowing to loiter within the compound without any work, and for purpose of canvassing or other things, and in the evening they used to collect money from some candidate. That is being recorded, videographed, and some vigilance committee, probably appointed by whom I do not know, they are regularly videographing that. Another thing was, yesterday some huge crowd was there in one particular court, and that court that was noticed by some registrar officials, resulting they were also followed and videographed, and I am told that 1,000 rupees cash was given to every advocate who accompanied the advocate who entered the premises of that particular court. These things I am only alerting because that I don't want that young lawyers should spoil their career and simply behave like ordinary politicians who run for seeking post or for money, and this is a highly wrong state of affairs concerning our status of legal profession. Therefore, kindly be alert and avoid these things so that there may not be any other proceedings against you, and you kindly concentrate on the proceedings. The advocates who remained in the premises, instead of watching the proceedings, they were one after other were talking each other, and some advocates are also just stalking. Best wishes.